G'day, Kim. How are you?
Hi, 200 episodes.
200 episodes.
How good is
Unbelievable.
that?
And we brought you on as a special guest.
Oh, no. First one for the year. Very exciting. But I do remember, and I was thinking about this morning, our 100th episode. It was a big production. We got clients in, people who were behind the scenes.
Spent money.
And we were meant to live stream it as we used to, rather than pre-record, and it didn't live stream.
And today we're having
tech issues as well.
our teleprompter
So
died on us.
we have to rely on
So we're going to be looking
paper.
down, but that's okay. Why don't we just kick off? I mean, can I just say before we do, it is the 200th, and I just want to thank the production crew that sits behind it. Esha, well done for the work you do.
Yeah.
Manette.
Yep.
David Carter. God, I don't even know why you do it for us, but it's fantastic.
Yeah.
Obviously, Tom, our administrative team, Sophie, Sal, Toy, who actually does the recording.
Yeah.
I'm sure we've missed lots of people, but this is not just Nina or I or three of us who do it. There is around about 7 or 8 people who actually make all this run.
Yep.
So thank you very much on our 200th episode. Why don't we kick off with the bullying, the application by Jacqueline Lachlan.
Yep.
This is a really interesting case, Kim, because the definition of worker under the Fair Work Act for the purpose of bullying comes from the WHS, from the Work Health and Safety legislation, which includes contractors, it includes students and volunteers. And this was an application by a director who felt they were being bullied. And it was a jurisdictional argument, and the court said, no, it falls within the definition of worker. We can hear the application.
Yeah.
So I just want you to understand, when we talk about bullying, particularly if you're a not-for-profit organisation or you have non-executive directors or even local government, schools, another example, don't think that because a director is not an employed or paid person for the purpose of it, they still fall within the definition.
Yeah.
So
simple definition really is that the person must carry out work and the work must be for the organisation, whether it's paid or not.
That's right.
So that's what the court found, the commission found.
Good stuff. Why don't we go on to the ETU and Ellencore, which is right of entry case. Interestingly, this was a case where Assistant Secretary turned up at a site where electrical wiring was being put up, for, mainstream electrical wiring across a large piece of territory. And what the company said is, well, they're all working on the lines at the moment. And anyway, it's construction. You can't come on, you're the ETU, without even contemplating for a second what the rules of coverage were for the ETU. And the fact that they're working on lines doesn't prevent them from meeting in a crib house. And you'll not be surprised to learn that the frustration of the ETU coming online was held to be unlawful. I just want you to understand, don't, as a matter of course, try and be too smart by half and exclude people from entering sites. This was just to meet. So this was to meet and discuss. The rules quite clearly of the ETU were broad enough to cover them, and they actually were carrying out electrical work as well. So when you're trying to be clever and sharp, all you're doing is empowering a union. And this was an easy win for the union, wasn't it?
Yeah, it was.
I want to go off. This is a case. The next case is a pretty simple case, which is Adriana Music and ShareSite. Not so much relevant now that we've had the changes of definition that's set under the Fair Work Act as to what is a contractor and employee. This goes back to the old common law definition of what was an employee. Here was a person who was employed, went on to a contractor relationship afterwards, but in all intents and purposes it was still employment, predictable hours, use of the tools of the business. And this related on the old personnel contracting case from the High Court and said, no, person's an employee. Why does it matter? Well, look, I just thought I'd tell you because the cases are still running. But the bottom line is, if the Albanese government lose at the next election, we'll be going back to these types of cases because the definitions that have been stuck in the Fair Work Act to overcome the High Court cases will be the first target of a new Liberal coalition government. So don't forget these cases exist because you never know, in 6 months' time they may be back on the agenda again. So more for historical interest than anything else. Return to office directions, not bullying. This is EELS and Equifax. Do you want to talk to me through this?
Yeah, so this one, two very different versions of events between employer and employee. There's a bit of a long history, not all of it's relevant, but she had a workers' comp claim, put her off work for a while. She was sexually assaulted one day working home from work, said the employer did nothing to support me through all of this. And then they received a complaint from a client, and they investigated that and ended up giving her a warning and performance managing her, which put her off work.
And can I just say that there is no doubt that that process had due process and was generous?
Yeah, it was all reasonable. And that sort of, she tried to paint a very different picture. So it's just a lesson. You never come to the commission and not to speak the truth, because it was her undoing in the end. She said she moved to Queensland to escape domestic violence. And then when the company directed her to come back to work at the end of COVID, she said it was unreasonable direction because they were bringing me back into a domestic violence situation, but they actually knew nothing about it.
The other thing that it does, Kim, and I think you and I continue to push this issue, is that documents are king in court.
Yeah.
No court really believes what people say, not because they're lying, but because their brain switches after 2 to 3 days into their own narrative and recollection of events based on how they see the world. But contemporaneous documents speak a truth. And this case is about contemporaneous documents demonstrating what was a state of knowledge and the actions that were taking. And it showed a company bending over backwards to do the right thing. Yeah. And that is juxtaposed to her story, which didn't line up at all with what the documents clearly said. So as Kim said, coming to court and spinning a yarn doesn't always work. I'm not saying she did it, but documents always prevail.
Yeah.
I want to talk about the next case.
Okay,
this is the Wakakiri case, which received such huge headlines where 22 people were killed in a volcanic eruption. The WML was the organisation that maintained the site, and then there were two companies that came on site. They were prosecuted because of management control. And they got a massive fine and reparations. And what happened is it went to the High Court in New Zealand, who said, no, management control historically means active management, and therefore they let them off.
Yeah.
Now, it is absolute horseshit. This is not something that will apply in Australia.
No.
A person who has an area of land which they occupy and control and allow people to enter will always be liable for the safety of that site.
Yeah.
This is a perverse decision, I've got to tell you, because it is not in line with the model legislation, which is what the New Zealand law
is based on. Yeah.
It is not in line with any of the historical decisions on what are management and control, but it also shows the regulator wrongly charged using management control rather than just primary duties. Because if they had have done under the primary duties, the management control issue would have fallen away. So there's a lot of bungling here, but it is a bad decision.
It is a bad decision.
All right, let's go on.
Do you need some water?
Well, I would if I had gone and got it, but it's too late for water, so we're just going to cough along. But I think Toy's leaving the room now as we speak to go and get me some water so I don't die on camera. I want to talk a little bit about directing people when they've been injured, whether it's physically or whether they've got a disease process, a mental health issue. When can an employer direct? What's the test, which goes back to Ramsey and Blackadder and is seen in Grant and BHP. But more importantly, because the most recent decision of Davies, what happens when someone seeks to frustrate that process?
Yeah.
And really this is all you, Kim, because this is what you do every day.
I was doing one this morning. It is frustrating.
Do you want to talk about Davies though? Because it's a good starting point, isn't it?
So this is one where we had long-term employee, so he was very well known to the organisation, but he was showing really obvious signs of mental health or mental injury. And they said, okay, and being a psychiatric nurse, he had a very highly responsible job, so he had to be fit for his job, which obviously. So these signs were started to show.
I must say I started life as a psychiatric nurse.
Yes.
I'm not sure that's true what you just said. Anyway, back to you.
So long of the short of it is if an employer has reasonable grounds to... Oh, geez,
You're turning up with the water here. You don't often see the live camera like this, do you? It's just great. I'll pour the water and try not to distract.
Okay, you drink. So if there are reasonable concerns held by an employer as to an employee's health and ability to do their job, they can make inquiries and require the employee to provide medical evidence. They tried to get the employee to provide or get his consent to obtain medical information from his treaters, refused to provide that. Next obvious thing for them to do was direct him to an IME. He refused, and they terminated him. He brought an unfair dismissal claim, saying their actions weren't reasonable. The court held absolutely they were, because he tried to frustrate the process. He didn't cooperate with lawful and reasonable directions, and he was terminated on that basis.
Yeah.
And there's a multitude of case law that supports an employer in that
And look,
process.
it's worth going back, in Grant and BHP, which followed Ramsey and Blackadder, which is the original case. What Ramsey and Blackadder said, if a reasonable person observing conduct, behaviour or the nature of a person believes they're unsafe to carry out the work, then it is reasonable to direct them, and that is a lawful and reasonable direction.
Yeah.
Lawful and reasonable direction is a direction at common law, which if not complained of is a fundamental breach of contract, and it's captured in Regulation 107 of the Fair Work Act. So, yeah. The difference, though, is in this area is, I'm cutting your lunch at this stage, but in this area a person may fail once, and that will not be enough because there is this sense of supporting vulnerable people, which means they'll be given a couple of chances.
Yeah.
And that probably comes to Beestis in the Star Casino case.
Yeah.
Which is a fun case. Okay, it's a guy. Well, it's not fun if you're the guy. He's a diabetic who couldn't wear vests because he got too hot, and he had constant problems as he wouldn't wear his vest, and they give him a direction not to do it. And his doctor said no, he's diabetic and he can't overheat. That's all uncontentious, but then something changed in the manner in which he behaved. So as he was resisting these directives to do it and bumping into people and they mishandling it, it was chaotic. His mental health appeared to go off the chart a little bit, and he started doing some really odd stuff, saying some bad things. And the organisation quite properly became concerned, said, look, we need to get you assessed, and these are the reasons. And he just refused. He said, I've got a physical problem, I don't have a mental problem. They said, well, based on what we've seen, we don't know what you are, but we're actually going to stand you down because we don't know if you're safe to be at work. Again, he was eventually terminated. He argued it was all wrong, and the court said, no, look, if you turned up to work with a limp and they ignored the limp, that would be a problem. If they direct you to get assessed because of the limp, that would be reasonable. Limp and mental health, they're just different sides of a coin. That's a proper thing to do. Right. And I guess that takes you through to a whole series of cases, but turns up at Laviano, which is Laviano and Fair Work Ombudsman, where a person deliberately failed to talk, to respond, to do anything in relation to directions. And the court said, look,
you can't not communicate with your employer.
They gave the three blind monkeys, the three monkeys saying you not talk, not see. If you're told to do something, you can't ignore them. And therefore, even though the person was on leave, because of the nature of their injury and it was a mental health issue, you cannot simply refuse to respond. And that's quite a difficult process because for you and I, we both know we're commonly dealing with people who are quite vulnerable, and therefore the nature in which we write them is generous and kind. We give people plenty of opportunity in which to respond. We follow up kindly. We make sure there are taxis, that everything is there, they're looked after. But it's still a lawful and reasonable direction, isn't it?
That's right. Just on that point, whenever you prepare any correspondence to an employee, I think it's very important just to remember this could end up in front of the Fair Work Commission. So you want to come out looking good as an employer. You don't want to be harsh and rude. You do want to be generous. Yeah,
and you don't want legalese in there or HR speak. We refer to our letter of the 7th of January. We note the following. I mean, why would you write to anyone like that? You've got to assume the person. And look, all these cases have some fun letters that you'll read and go, like Business has some fun letters in it. Just be nice. Just it's not hard, and it's how, if you just think, if this was my child, how would I like to write to that? How would you want them to be written to? Because there is any time you use formal language, you take a position of power, and the moment you take a position of power, you've got the Fair Work Commission against you every time.
Correct.
Why don't we head over to the case study?
I like this one.
And this is, I think this is a good case study. Over to you, Kim.
Okay.
Go.
So Doris felt under attack. Her boss, Ruby, had become more aggressive in enforcing the flexible work arrangement of 3 days at work, and Doris couldn't stand it. Ruby had consulted with the union and workplace delegates in early 2024, and it was agreed that by 1 July 24, everyone would return to work 3 days a week in the office and 2 days working from home. A roster was created to ensure overlap and efficient use of the office. The change kicked off to a rocky start in July, but By the end of the moratorium period on 1 September 24, everyone except Doris was complying. Rather than attend work, Doris began taking sick days, having accumulated over 93 days. Her medical certificates indicated that she had an adjustment disorder and could not safely return to work. Her GP had failed to return calls or agree to meet with Ruby's HR and return to work team. Ruby directed Doris to see a consultant psychiatrist to assess any impairment and determine what adjustments, if any, were necessary. Doris called 2 hours before the first appointment and claimed her car had broken down, preventing her from attending. A second appointment was made and taxis were arranged, but Doris refused to respond to calls or confirm her attendance. Ruby cancelled the appointment, made a new one and sent a letter stating that it was reasonable and lawful direction and Doris must attend. Doris ignored the letter and did not attend. In response to a show cause letter sent 1 day after the expiration of her 93 days of accumulated personal leave, that's important, from Ruby regarding her breach of the direction, Doris claimed she felt bullied by Ruby to return to 3 days a week and that she was being targeted due to illness. She argued that there was no need to force her to attend independent medical examinations as her treating GP had made it clear that she was unfit for work. Okay, so Andrew, did Ruby and her business breach safety law by requiring everyone to return to work without individual consultation, failing to intervene earlier before her personal leave was used up and forcing her back to 3 days a week?
Interesting. Because can I just say to you, probably not. But what I will say is the individual consultation is a critical part of any major change. It was a major change under an award, which does require individual consultation along with group consultation.
Yeah.
So there may be an award breach, very small, and there is an argument that could go to safety law, but there is a lack of nexus between the individual consultation and the subsequent harm, which would do it. The rest of it, I'm afraid they've done everything right. So I think the chances of this ever ending up in a safety jurisdiction is absolutely zero.
Yeah.
So, Kim, did the threat of termination violate the temporary absence provision?
No, it didn't, because she was off work for a period of more than 3 months and she'd had at least 1 day unpaid leave.
After the expiry of her accumulated
3 months.
Well, her accumulated leave.
Yes.
So it can be over 3 months. If I had 120 days, it'd be 121 days.
Right.
Before the temporary absence provision kicks in.
Yeah.
Kim, could Doris have sought a stop bullying order at any time?
The employee's conduct did not constitute bullying.
No, in fact, it was reasonable management action. So I think that's a no to that one as well.
Yeah. Yep.
Okay, let me give you another one. Was her proposed termination discriminatory or an adverse action?
Not where... Sorry, I'm reading my notes because all the technology's died. Sorry. Where the refusal...
I am the technology here. Do you understand? You watched my nose. Yeah, there you go. Sorry, Kim.
We might have to redo this one. Wasn't discriminatory because of her... It was due to her refusal to participate in the process.
Well, the argument is it discriminatory because she had an adjustment disorder and the argument would then be that no proper adjustments or intervention occurred, but she wouldn't allow them to assess her. And
to determine if adjustments were...
It was.
Yeah,
so no,
required,
discrimination and general protections are both out, even though there's a reverse onus in general protections. So let's stretch a bit here. What about workers' compensation? Because part of this is not performance management, so it's subjective assessment of pain. So would she have a workers' comp?
Oh, I was thinking in terms of the directions to bring her back to work would be reasonable management action. Could be,
but it's not performance management. The direction to come back to work wasn't performance management.
Yeah, but management action isn't always performance management.
No, it's not.
This it would be.
I think there's a risk of subjective element playing. So just to be clear, there's two parts that come in workers' comp.
Yeah.
If you're part of any management process, it's a direction, a requirement, or I'm actually managing your conduct or performance, the defence of reasonable management action, that is that there was a fair reason for doing something and it was done in a fair way, apply. In every other part of workers' compensation, it is your subjective personal experience of something that occurs that creates liability. Yeah. And there's enough in this story where she could, and remember regulators are generous in this process, where she could hang her hat and say, but look, they didn't help me, they didn't assist me, I felt lost in a process. I think there's a chance that a claim could be accepted.
There's always a chance in workers' comp.
Yeah, and look, if we go through it, I mean, in South Australia, probably not accepted. In Victoria at the moment, probably. New South Wales, definitely accepted. Queensland, probably not. It's crazy, isn't it? We get to a jurisdiction by jurisdiction, who's got the hammer as to what's going to happen. It's just nonsense workers' comp law, isn't it?
Yeah.
Did Ruby act lawfully?
I believe so.
I think Ruby acted lawfully. Well done, Ruby. So that's it for this week. By the way, we've got coming out Workplace Watch that talks about the new psych regs and the new suggestions that sit around sentencing in OHS and Victoria and how they apply across Australia. That'll be out in the next day or two. So please watch out for that. Otherwise, number 200, we've done it, Kim. Without technology, we've done it.
Yeah, it wasn't great.
Give us a thumbs up. If there's anywhere to give us a thumbs up on that technology, just give it to us. Thank you very much. See you later.